Good morning, everyone, and welcome to the Pitch Perfect panel. My name is Michelle Pickett. I am a partner at PwC in Toronto, Ontario. I am on the network, on the IWIRC board. I'm also the network chair for the Ontario Network. And I'm thrilled to be here this morning to introduce our panel to you and tell you about Pitch Perfect. The team of Lori Vaughn and Margie Kaufman and I have been working on this for quite some time and had a lot of fun with it, so I hope you guys enjoy it as well. So just to put some backdrop on this and explain what we're going to do this morning, we have a company, OO-Orange, which is facing some challenges, and its management team has reached out to a team of financial advisors, legal advisors, and claims agents to see how it will help them maneuver its challenges and help them with devising a strategy to be able to deal with those challenges. So from OO-Orange today, I have their CEO, Catherine McEachern, on the left. I also have Patty Missel, who's the CFO of OO-Orange, and Leslie Burkhoff is the in-house counsel for OO-Orange. They will be the judges effectively on today's panel as they listen to all the various pitches from the legal advisors, financial advisors, and the claims agents and assess how their strengths and how they can help them with their challenges. So just some timing in the schedule on what we're going to do. Each team will get 12 minutes to make their pitch, followed by 8 minutes of questions from the judges, and then we'll change. So we'll go through all three pitches first. At the end of the session, we will allow time for the audience, for you guys to ask any of the teams or the judges any questions that you may have with respect to the case study, any of the issues, or just pitches in general and some of the challenges that you may face in doing pitches, especially under such short time constraints. The bios for all of the teams are located in your program, but I will make brief introductions to each of them, starting with the judges themselves. I'm going to sit down to do that because they're all on my computer. Okay. So Catherine McEachern is a lawyer with Blake Castles and Graydon in Toronto. Catherine is an experienced litigator who has acted for debtors, financial institutions, receivers, trustees, suppliers, and other creditors and stakeholders in all types of insolvency and restructuring proceedings, including court-appointed and private-appointed receiverships, proposals under the Bankruptcy and Insolvency Act in Canada, and the Companies Creditors Arrangements Act. Catherine acts regularly in cross-border proceedings, and she is a director of the Ontario Network. Patty Missel, which is to Catherine's left, is the managing director of the Numbers Group, which is a consulting firm based on transitional financial management, financial and forensic advisory service based in Ohio. Patty has over 25 years of experience. Her most recent engagements have included serving as interim CFO for a $170 million service company, testifying expert in a planned confirmation hearing for a plastic manufacturer, and testifying experts for the debtor in a Chapter 11 case. And Patty is a former chair of the Northeast Ohio Network. General Counsel Leslie Burkhoff is a partner with Morit, Hawk, and Hamroff in New York and serves as chair of the firm's bankruptcy practice group. Leslie concentrates her practice in the area of bankruptcy and restructuring litigation and corporate workouts, and she represents a variety of corporate debtors, trustees, creditors, and creditor committees, both nationally and local. Leslie is a former chair of IWIRC International and a member of the New York Network. So team one this morning, our legal advisors, are from Vincent & Elgin, and I have, to my immediate left, Jim Lee, and to his right, Becky Peterwright. Welcome to both of you.
Thank you.
Becky is an associate in the Restructuring and Reorganization Practice Group of Vincent & Elgin, which is in their Dallas, Texas office. And Becky's practice includes all aspects of restructuring and reorganization work, including the representation of debtors, lenders, creditors, landlords, and trustees. She also has a significant experience representing clients in contested matters and adversary proceedings, both before the federal bankruptcy and district courts. She is a director on the board of the Dallas-Fort Worth Network. And Jim Lee is a partner in the Vincent and Elkins office in Dallas, Texas. He's an accomplished lawyer with over 37 years of experience. His practice focuses on complex commercial litigation with a special emphasis on bankruptcy litigation. So thank you to both of you and welcome.
Thank you.
And you can have the floor.
Thank you so much. Good morning. Just to introduce ourselves again, Jim Lee from Vincent and Elkins with Becky Peter Wright.
Thanks
And
for having us here today.
we very much appreciate the opportunity to talk to you about Oi Oi Orange, or may I just call it Orange? Thank you. Okay. Well, we've had an opportunity to look at the brief information that you provided to us. We've seen the capital structure, we've seen your organizational structure, the fact that you are a cross-border organization. We've also looked at the situation that you face now with increased competition, a lot of pending litigation that's going on with the result of some of your products, and the fact that you're having diminishing returns and need to downsize. And it would appear from your lack of unencumbered assets that you also need to restructure your balance sheet. We think that the best opportunity here for you is going to be United States or domestic Chapter 11 proceeding with possible cross-border implications involving Canada. Admittedly, we do not have an office in Canada, but we have extensive experience working cross-border matters, and we have certain Canadian firms that we have regularly affiliated with. Our assessment of the situation is the majority of the activity would be in the U.S. bankruptcy proceeding. In any event, and it's possible when we learn more about the facts that a Canadian proceeding may not be required at all. As is typical, when you're faced with problems like this, no one wants to talk about bankruptcy. And I'm not here to sell you on bankruptcy per se, but to tell you that based on the information you have provided us, and we would obviously want to spend more time visiting with you about details, but it looks like you're going to have a severe liquidity crisis that is going to compel you into a bankruptcy rather than the opportunity to negotiate something or have a prepackaged plan. That is heightened by the problem you have with 4 CBAs or collective bargaining agreements that are due to expire. And in our experience, you need the leverage of a bankruptcy. It's very difficult to get unions to cooperate on a prepackaged plan. And in the interim, we do not see where your liquidity is going to come from to maintain operations. So we think that a Chapter 11 proceeding where you have the ability to ask for cash collateral, we have the ability to seek DIP financing, and you can get some breathing room is going to be the way to go. A couple of things that are of note with respect to why bankruptcy. You need to prevent your debt enforcement. My understanding from what you've told us is that you're going to have problems because you're in default on your bank facility. That doesn't give you much time to maneuver, especially to seek to refinance under a leveraged position like this. So we think you can get breathing room by filing a proceeding. We also think that once you're in bankruptcy, you will find that you have a much more strengthened bargaining position when you go to negotiate with the unions. And clearly, if you're hoping to come out on the other side as a slimmer, more efficient organization, you're going to have a longer-term agreement with your various unions. September 14th will be here before you know it. So the other opportunity, we don't know from the materials you provided us, but it does appear you have a tremendous amount of retail operations and you need to close some of those. It seems that process has already started. In that type of a situation, we've got to know more about whether you own the real estate or you're leasing it. But in the event you're leasing it and they are unprofitable stores you're wanting to get rid of, bankruptcy, again, is a great mechanism for rejecting these leases and for coming to terms with landlords that may be more favorable for you. And these are things you're going to have to do in order to restructure your business. There's another side to the equation that we think you ought to talk about amongst yourselves, and then we can help advise you on, and that has to do with the fact that when you entered in to your arrangement with Yoga Bank, it appears that the entirety of your $100 million term loan was used to pay off other debt. And my immediate reaction is to look at whether or not there might be some fraudulent transfer issues there, where you can unwind those transactions, which will give you greater liquidity. And so that's something, I'm not saying it has, in fact, been that case, but a constructive fraudulent transfer analysis should be analyzed, because I don't see where the company really got the benefit of that new loan. It looks like it was simply a conduit for passing money out the door. So we would encourage you to evaluate that, and that's something we have very extensive experience in, as Becky can talk about. And the other thing I think that you need to consider here is, what are your goals going through? Right now, most people have a stopgap attitude when they're faced with these types of situations, and you're worried about the immediate problems that you're facing, making payroll, issues of this nature. But you have to start projecting outward and including, although it's tough to talk about right now, but including evaluating your management and whether they're the appropriate people for going forward, evaluating whether or not the type of capital structure you have can work in your new, more competitive environment, or if you need to try to convert some of the publicly held equity into debt. Debt into equity. One thing I don't know is, it did say you have $100 million of unsecured debt, but we don't know if it's publicly or privately held, which will make a difference on our negotiation strategy when we learn more details. Because clearly, if you have some hedge funds and others that are holding that debt, it will take a different tact than trying to deal with public debt holders. We also have to learn more about what it is you think you do well and what it is you think you have problems with, so that we can help you. Now, why V&E? I think one is we've had a very, very deep and broad experience in bankruptcy matters, especially debtor cases. I personally have worked on numerous debtor cases over the past almost 40 years and have handled every type of litigation that you could imagine with respect to debtor cases, be it cash collateral fights, any type of thing of this nature. We have very experienced lawyers in our restructuring group, but more importantly, as a 700-lawyer law firm, we can draw on every discipline needed if you have tax issues, corporate issues, things of this nature. So a team approach is what we always use internally, meaning we try to assemble the best members of our team going forward, and then with the client. If you don't have a team working together, client and lawyer, your likelihood of success is going to be jeopardized. And so we're very focused on learning your business as fast as we can, on learning the strengths and weaknesses of your personnel, on learning what we can do to assist on that side of it, and also on making recommendations to you about potential financial advisors and other professionals that may be needed to help you. We also have a great network of connections through our years of experience. So when it comes to needing introductions for DIP financing and things of this nature, we will do what we can to facilitate that. But most importantly, we believe we can provide the type of guidance that you will need to see yourself through, because our intention is not to liquidate, our intention is to reorganize here. And based on what we've seen, we see no reason you can't do that.
And just to follow up on some of that, we did bring materials for you today. It sort of lays out some of our relevant restructuring and litigation experience. Didn't want to give that to you up front so you wouldn't be distracted, but we would love for you to flip through that, and it sort of sets out some of the relevant strengths and experiences that our firm has, our various offices, like Jim mentioned. We have high rankings in so many different disciplines that any sort of issues that merge practice areas, we're going to be able to address that effectively and efficiently for you. And we do have offices everywhere. So, for example, we saw that some of your key vendors are in Southeast Asia. We have offices there. We have expertise there. And then also in your materials, we've provided a list of some of our relevant retail experience, too, that's particularly relevant to your situation.
Another thing I wanted to mention, it seems to be, if not an impetus, a great concern for where you are now is this pending litigation. I think I understood there were some 200 lawsuits. And although you don't think you're going to have any ultimate exposure, you clearly are having expenses, and obviously management's going to be distracted dealing with those. There's nothing in what you've told us so far to say whether or not you may ultimately have insurance that will cover those. But regardless, you can't restructure a company while you're fighting that fight. Chapter 11 will provide you the breathing room that you need and an opportunity to deal with a collective amount of litigation on a much more efficient basis, and to be able to address it in such a fashion that when you come out on the other side, that problem can be solved. This is a tough thing to do if you're trying to do a pre-pack, because a prepackaged plan would require being able to marshal all of those different law firms that are handling these lawsuits, to get them in agreement, to have one part. It's almost like trying to get a class action through, and if you have experience, you will know that that's a difficult process to shepherd through. So we think that a Chapter 11 is going to give you a much more viable mechanism for dealing with that pending litigation as well. Clearly, you will have anticipated restructuring costs. It's not easy to go through a bankruptcy. It's expensive. You have to pay lawyers. You're going to have to pay financial advisors, most likely. There will be fees associated with any kind of a new financing that you may be able to negotiate. So we are very attuned to that. We try to be as efficient as possible in guiding you and to offering you opportunities to make decisions along the way, so that we don't bring you just, this is your only opportunity, this is your only way of going, but we try to, as early as we can at each stage, tell you what the various options would be, the advantages and the pitfalls and the costs that would be associated with selecting those various paths, and then let you make a business decision with the benefit of that guidance. Because we are lawyers, and we're not here to replace the business judgment of management and the owners.
Whatever your goals are, we can help you achieve those. And so I think we've kind of told you a little bit about us, and maybe if you have any questions or want to tell us a little bit more about your goals and how we specifically can help you, we're happy to do that.
Great. Sure. Thank you very much, both of you. That was very good and very well handled. What I want to do actually for seconds to go back, I realize that only one of the screens has the case on it and the other one doesn't. So if you're in the back, I'll just do a quick recap of the case before we actually get some comments from the company and some questions for the company. So OO Orange is the name of the company that we're dealing with today, and it's a manufacturer of women's workout apparel. It's publicly traded on the NYSE, and historically and to date, its customer base has consisted primarily of upper middle class women. Maybe some of you may have worn OO Orange clothing this morning on your runs or when you were doing Pilates. So OO Orange.
I know Jim did.
For sure.
Orange purchases raw materials from select high-quality vendors in Southeast Asia, as Becky discussed earlier, and designed and manufactures its products for sale on a wholesale and retail basis at 5 manufacturing facilities located in North Carolina, Alabama, and Canada. It has a wholesale operation which distributes its products worldwide through a network of 20 distributors. In addition, it operates a network of 400 stores, 100 in Canada and 300 in the U.S. The Canadian stores are actually held in a separate Canadian incorporated company. The company has 2,800 employees, 1,400 of which are unionized and under 4 collective bargaining agreements. Each of the agreements includes defined benefit pension plans for retirees, and 4 of those are set to expire in September 2014, which Jim mentioned in his comments. Orange has $600 million in annual revenue, and it has a $250 million first lien credit facility with Yoga Bank, and that facility is in default as of December 31st, 2013, and liquidity is forecasted to be a problem for the company. Some of the issues that Orange is facing is its retail operations are underperforming, and the company is considering a plan to reduce its retail footprint. As Jim mentioned, sales in 2013 were 10% lower than they were in the prior year, and that's due to increased competition in the high-end workout gear market and negative press due to some impending litigation that they have. In part, Orange has been named a defendant in over 200 lawsuits filed in the US and Canada, seeking damages for emotional distress and embarrassment, along with other consequential damages due to defects in the product, which made them transparent, supposedly, or allegedly. One of the key events was there was an outdoor yoga class, which resulted in a 10-car pileup due to this transparent fabric. Is it all coming vaguely familiar to people in the backs of your mind based on some other case? So while Orange has defended its product and believes that the lawsuits are unfounded, the lawsuits have survived the motion to dismiss stage, and it's also already spent more than $2 million in attorney fees and costs defending the lawsuits. So it has a number of issues, which is why the company has reached out to some advisors to help it. So on that note, I will hand it over to the company to ask any questions that they may have of these legal advisors.
Thank you so much. You certainly covered quite a lot, but as I'm sure you're not surprised to hear, this is clearly the first time we're facing anything along these lines. For the past period of time, we've dealt with spending well over $2 million. That's just in outside counsel fees, not exclusive of the time I've spent dealing with these lawsuits. There are a tremendous amount of issues, and I think our biggest concern is really understanding what the process is about. And by that I mean, how long does this take? And I know that you touched upon the fee issue, and I suspect if I asked for a budget or something like that, it would be perhaps premature. But I think we really need to understand the timeline here so that we can understand how this really affects us on a day-to-day basis, or what we are looking at going forward in terms of perhaps closure, because that's going to play into our decision.
Well, I mean, those are very good questions, and most of them are hard to answer at this juncture, because until there's a decision made about what you want to try to do ultimately, is it downsize the company, is it sell off some assets, what your approach is going to be, it's hard to give you an actual timeline. However, I think you can look at the fact that you're probably talking about a year minimum in the process. During that time, however, because you're in a Chapter 11, you will still be operating the company, but you'll be able to operate the company with the benefit of some protections, such as your creditors are not going to be able to enforce their claims against you. The litigation will be stayed initially by the automatic stay that's provided when you file a bankruptcy, and then will be dealt with in a more orderly fashion. You will be able to use cash collateral, assuming we're successful in getting that opportunity, and then you will therefore solve your immediate liquidity concerns while you try to negotiate, and if not successfully negotiate, litigate the restructuring of your balance sheet. So depending on what happens, bankruptcy is one of those interesting things where it builds, if you will. It's kind of a domino process, and until you know how the first couple of tiles are going to fall, it's hard to predict what's going to happen down the chain. I wish I could be more specific with you, but until you get into the case and see what the creditor's attitude is going to be, what the union's attitude will be, et cetera, we're really guessing.
And just to add on to that, it depends on your goals as well. And we have been able to shepherd some cases through. Jim gave sort of a year estimation, but we have been able to get several very large cases through bankruptcy in less time than that. And I've included some of those examples in your materials. But for example, Spectrum was a case that we did in 2009, and it was one of the largest Chapter 11s filed in that year, and we were able to get that through in about 7 months. So it sort of just depends on the situation.
I have just one further question. You mentioned the creditors, and we've all obviously done a little searching on the internet and have heard scuttlebutt from our fellow business folks. I've heard about these things called creditors committees. They kind of band together. We pay all these ridiculous fees, and they run amok in the case. It's rather a scary concept. Can you kind of maybe address that, because we're a little bit concerned.
Sure, I can. Essentially, what we're really talking about is what's called an unsecured creditors committee, that in a bankruptcy process, because you may have a variety of different unsecured creditors, some are trade, some may be lenders, like you have $100 million of unsecured debt, et cetera. The bankruptcy code allows for a committee to be formed and compensated by the estate, you're correct, to represent the interest collectively of the unsecured creditors. And what happens is the U.S. Trustee's Office, with the guidance from the loudest and usually the largest unsecured creditors, will appoint representatives who form a committee. They then have the right to retain their own lawyers and to retain their own financial advisors typically, and sometimes accountants as well, depending on the complexity of the matter. And the estate will compensate them. While it is a burden, there is also a benefit, because you now have a centralized group that you negotiate these issues with. And it's a lot easier than having to do one-offs with a myriad number of unsecured creditor constituencies that you may deal with. In practice, what happens is when you're budgeting your case and you're doing your restructuring plans, that is a cost component that is taken into account, just like your own lawyers and other professional fees will be.
Thanks very much. As you know, part of our business is in Canada, and a large number of stores are there. We also have some of our plaintiffs, unfortunately, have sued us in Canada. So I'm wondering if, you said wasn't clear whether you need a filing in Canada or not. Will the Chapter 11 proceeding deal with those plaintiffs?
Well, you can have a Chapter 15 proceeding, which allows for more cross-border that's associated with it, or if, when you evaluate the particulars, you feel there's a need for a proceeding in Canada that is affiliated with the proceeding in the United States, you can do that. And cross-border between Canada and the United States actually is one of the most cooperative processes. It's not like being in a lot of other countries where they don't recognize our bankruptcy process, don't have anything very similar to it, and have much more stringent rules, which is essentially liquidation in almost every instance. Canada is big into rehabilitating, so we believe that that can be managed, and we think it's best managed from the United States, where the majority of your assets seem to be. While it's not stated clear, I think Yoga Bank is a domestic lender. It's important that your secured lender be somebody who you can work with, who doesn't think that you're running across the border to gain leverage against them, et cetera. So that's a very important thing to try to shorten the length of the bankruptcy. You want to have the least amount of conflict as possible with your secured lender, in the hopes, quite frankly, that you can restructure that debt as opposed to having to replace it.
And in fact, just last year, we actually did represent Lone Pine, which was an oil and gas company that was the reverse. Primarily, its assets were in Canada, but we filed the action under Canadian laws, and then we had an ancillary Chapter 15 proceeding here in Delaware. So we do have experience with handling both of those.
Okay, that's very helpful. I had another question relating to my role as an officer and director. We're somewhat exposed to some of that litigation as well, and it has been distracting us from the operation of the business and trying to get down to the restructuring and getting this thing profitable again. Can the bankruptcy proceedings help with the litigation that's against us as well, the directors and officers?
Go ahead.
Absolutely. As Jim mentioned, it would really kind of give you some breathing room, because there would be a stay over that litigation. And that would give you some time to focus on these issues that are really pressing right now, which is why we do think that a bankruptcy is a good option for you right now. And then to the extent that litigation arises within your bankruptcy, Jim and I have extensive experience doing, avoidance actions or various adversary proceedings, and would be able to help you with that as well.
And a little more to your point, because I understand your personal concerns. The courts have been quick to recognize that if a company is in bankruptcy and Chapter 11 where management is still actively involved, and yet management is being distracted trying to defend itself in merit litigation, that is going to impede the Chapter 11 process. And virtually every court I've been in front of has been sympathetic to that and will provide that management can continue in its role and not be distracted, and will stay the litigation against management as well, even though management is not technically the debtor, until matters get resolved and under control. So I feel that we can deal with that.
As a financial officer of this organization, I've heard a lot of talk about planning, timing, and costs. So as we're evaluating our new business strategy going forward and all of these risks, and options, you have retail experience. You know how thin margins in retails
We
are.
do.
You keep saying downsizing. I like to think of it as right sizing.
It's a better term.
So, given that, and as we look at this going forward, knowing I'm operating on thin margins, I hear fees for our own advisors and attorneys. I hear fees for creditors' committees. I hear fees here, fees there. I don't have that much money to work with. Will you, if ultimately we can't put together a plan that we think we can pay all these fees and come out on the other side and really have money for shareholders until 5 years down the road, kind of what are our options at that point?
Well, one of the toughest issues you're going to have to face, and it's unclear here, but a lot of times, if the company is in dire enough straits, and I don't know enough yet, but if you are, then your equity may get wiped out. And that's just a fact of life. They took the higher risk on the investment totem pole, and it may be that what happens is, to deal with your deleveraging, you have to convert a bunch of debt, as I mentioned earlier, into equity, and existing equity may get impaired or wiped out. But that is one way you reduce your cost dramatically, and you can still come out on the other side as an operating company with a balance sheet that's been cleaned up and with pro formas that will work. Clearly, we work hand in hand with your financial advisors that I know you're going to be interviewing and hopefully retaining, who are much better equipped to tell you, this is what you've got to do. Maybe there's certain SKUs you need to eliminate because they've really been, killing your bottom line, and you can be much more profitable. You can increase your margins. You can do things of this nature by making some adjustments in your business model that are separate and apart from your capital structure. Those things have to work hand in hand when we try to put together a plan, and we've got to come up with something where we and the financial advisor can present to your largest creditors something they'll buy off on, hopefully, or at least find a substitute creditor that would. One thing we haven't talked about, but we may be able to arrange for debtor in possession financing, and with the assistance of your financial advisor can look for that if your existing secured lender's not interested. And at the same time, while you're not having to service all of your debt, you will have access to cash collateral and new funds to help right-size, and that's that breathing period that Chapter 11 is going to give you. Ultimately, there's always the risk that you can't get it done, but based on what we've seen to date, we don't think that's what's going to happen here. We think that you've got a good product. We think that you've had a good, successful model, and it just needs to be, as you say, right-sized.
All right, thank you.
Thank you very much both for coming today. I think the company will be in touch with you shortly once it's made its decision and decides which route it wants to take to deal with its issues.
Great, thank you.
Thank you.
Good morning, ladies.
Good morning.
Thank you very much for joining us today. As we said earlier, we have here the management team from OO Orange who are looking for some assistance and are interviewing financial advisors and legal advisors and claims agents. So what I have with me here today is a team of financial advisors from Conway McKenzie. To my immediate left, I have Maggie Connor, who practices in the Houston office of Conway McKenzie, where she specializes in providing restructuring support and bankruptcy case management services. Maggie's experience includes advising a variety of debtors, official committees of unsecured creditors, lenders, and trustees regarding complex restructuring and litigation related matters. Maggie is a director in the Houston network. To Maggie's right is Danielle Iafredi. She is a senior associate in the, I call it the Detroit office, but I think it's the Birmingham office of Conway McKenzie, and specializes in providing turnaround, consulting, and crisis management services to companies in a variety of industries as well as government entities. Danielle is a member of the Michigan network of IWIRC. Good morning, ladies, and here's the management team of Orange.
Thank you for having me.
Good morning. Thank you all very much for letting us present to you guys. I know that you've been interviewing council, and I'm sure they've done this as well, but Danielle and I have really taken some time to try and understand the initial information y'all provided, and we've identified at least 5 critical issues that we think you guys are facing that we can help you look at some solutions and take some actions towards resolving. So I think just to identify those off the bat, I think that we have some products defect issues that we really need to address quickly. I think first, with respect to products defects, we're going to have some customer faith in our product that we need to focus on. We also, secondly, have some litigation we need to focus on. Third, we're going to need to diagnose the financial health of the company and look at financing options. Fourth, I think that we need to look at your various retail locations and perhaps decrease or change, be more strategic in our footprint of the retail stores. And last, we need to look at the collective bargaining agreements and use the tools that may be available to us in the bankruptcy process to help get some better terms for y'all. Before we jump into those specific critical issues and look at what those issues are, and then also what our strengths are, what are your competitive advantages, and the action steps, I want to just step back and give you a little overview of who we are as Conway McKenzie. Danielle and I will give you all a little background on our own experience, and then Danielle will provide an industry overview. Then I'll dive into those critical issues, help present some solutions, and then we would be happy to address any questions that y'all may have for us. So to start off, Conway McKenzie is a turnaround and crisis management advisory practice. We're in our 26th year now. We're based out of Detroit historically, and we now have 11 offices in North America, as well as internationally in Europe. We provide a range of services, sometimes out-of-court workouts, and we often lead companies through the Chapter 11 restructuring process as well. We have a wide variety of industry expertise, including auto, energy, and Mr. Germain here, retail. I know personally I've worked on a number of retail furniture cases in particular, so we have a lot of experience in y'all's area. I personally have a background actually in law. I practiced as a bankruptcy attorney for 10 years at 2 of the top 10 international firms, and I've had the pleasure of working with 2 bankruptcy judges. I flipped over about 2.5 years ago to become a financial advisor, so I think that our team has something truly unique in the financial advisor world because we have a very efficient bridge between finance and law. So we'll be able to have a very holistic strategic approach to evaluating your issues, and we'll also be able to work very effectively to keep costs down and work together with your other professionals. We have a great relationship with Vincent & Elkins that I know you all have been visiting with. In fact, just this past January, they called us in on a private label bottled water company, and we worked together. We were so successful that we had a successful sale and avoided the bankruptcy process. So we've done some great work with Rebecca and Jim's team before, and I'm sure we could do that again. So I'll let Danielle give you a little of her own background and some industry background, and then we'll hit the hard issues.
Thanks, Maggie. So if I may tell you a little bit about myself, my name is Danielle Iafredi, and I specialize in providing turnaround consulting and crisis management services to companies in a variety of industries, as well as governmental entities. As Maggie indicated, she has more of a legal background. My background is more financial and accounting. I am a certified public accountant, and prior to joining Conway McKenzie, I worked at a Big Four accounting firm and provided audit services to clients with up to $150 billion in revenue. So on that note, I'd like to go through some industry observations. We understand clearly Orange is in the textile and apparel clothing industry. The women and girls apparel manufacturing industry is currently in a state of decline with low levels of domestic product innovation and a slowly decreasing number of industry operators. Competition from imported goods, as I'm sure you know, has led to overall industry revenue drop at an average annual rate of 4% over the last 5 years to $4.6 billion today in 2014. With most apparel production moved to low-cost overseas manufacturers, domestic companies satisfy a relatively small portion of total demand. Imports will satisfy approximately 92.8% of the total value of domestic demand in 2014. There's a lot of high competition from imports and recessionary pressures on domestic demand that have hurt apparel manufacturers. Industry companies that are still in business are shifting their product mix from low-cost apparel to higher cost, higher quality apparel, such as what you all produce, to help prevent profit from plummeting. Expectation is for revenue to decline at a more moderate average annual rate of 3.5% over the next 5 years through 2019, and total revenue is expected to be about $3.9 billion for the industry. I'd like to just briefly go through a few key competitive success factors. Number one being the establishment of export markets. Number two would be the access to a multi-skilled and flexible workforce. Number three would be the ability to alter goods and services produced in favor of market conditions. Number four would be access to niche markets. Number five would be economies of scale. And number six would be access to the latest available and most efficient technology and techniques. And with that, I'll hand it back to Maggie so she can begin to go through some of the most critical issues identified with your company.
Thank you. So as I said, we're already familiar with some of the key issues that are immediately facing y'all's company, and we're ready to help you guys respond. I think that certainly you guys have so many distractions now. What we need to do is come offer some guidance, propose some solutions, and really let you guys as the management team get back to focusing on running your business. So one of the first issues regarding product defect issues is the customer's faith in the product. I know that y'all have an exceptionally strong customer base of high quality products targeted towards upper middle class women. And so we need to make sure that we take very quick and effective action to address the product's defect issues that have arisen, and make sure that we respond to some negative press and really restore the customer's faith in the quality of our company's product. Our proposed solutions are just quick action and effective communication. I think it's important for us to identify the cause of the problems with the product. We need to take decisive, effective action to correct those problems, and we need to specifically identify for the customer what we've done to fix those, and reassure the customer that the product issues have been resolved and that the company is going to continue to operate. We have a number of tools in the bankruptcy process if we choose that route, including customer programs motion that will help reassure the customers and really address this concern. And then if need be, we could always hire a PR firm that can come in and provide some expertise on communicating with their customers also. Second, with respect to product defect issues, I know that you all face over 200 lawsuits, not only here in the United States, but also in Canada. One of the things that I got to do as national counsel when I worked at Aiken Gump was to really coordinate litigation on a large scale, and it's very important, I think, to have a unified plan. So we would work hand in hand with Vincent and Elkins to make sure that all of these various suits are dealt with in the most efficient and homogeneous manner. I think that filing for Chapter 11 protection is going to invoke the automatic stay here and give you guys a breathing spell that we need to really curb the legal costs, stop the destruction of those litigation matters. And then, as particularly Catherine is aware, there'll be issues regarding the proceedings in Canada also. At Conway, we have a lot of experience working with companies that have operations not only in the United States, but also Canada, Mexico, and around the world. In fact, about a year ago, I was working on an auto parts remanufacturer case, and we had similar issues where we had operations and companies in Canada and litigation there. And so, as you know, we have some tools with respect to recognition proceedings, so that when we file a Chapter 11 case, if we do so here domestically, then we can also file a motion in Canada to enforce the automatic stay there to make sure that our vendors and the litigants and our customers in Canada are aware of the process here for bankruptcy, and make sure that we also have, perhaps a foreign representative, and that we have the same protections in the U.S. and under the Companies Creditors Arrangement Act in Canada. So we can really work hand in hand with Canadian counsel to effectuate that. So we'll be able to handle the lawsuits. Third, we need to look at the retail footprint. I know that you guys as a management team have started this already, and I think that we have some strong locations, and we have some less favorable locations. So you can kind of think of us as the financial emergency room doctors. We have to figure out which are the stores that are, bleeding out that we need to just cut off, and which are the ones that are really in great market areas that we can focus on. So we'll look at your retail footprint. We'll make some strategic calls to help you guys really focus on your retail operations. We've had a lot of success in negotiating with landlords. Certainly under the bankruptcy code, as you know, there's possibility to reject leases, and so we'd run some lease rejection damages calculations and really negotiate with them to give you guys some flexibility and an increased focus on your retail footprint. Next, we need to look at financing. You guys have a clear liquidity crisis, and so we can help you either go back to Yoga Bank and perhaps seek debtor in possession financing for them. I also know that there are some unsecured bondholders that may be willing to provide financing, and so there is also a possibility to have not only an unsecured creditors committee, but an ad hoc bond committee, potentially from those folks too, so we'll watch out for that. But we can help you obtain the new financing. The last thing I think we really need to focus on is the collective bargaining agreements. I know that you guys have 4 of those, and that they're set to expire now in September of this year. But even before those CBAs expire in September, under Section 1113 of the Bankruptcy Code, we have a lot of flexibility to renegotiate those. Certainly coming out of Detroit, Conway has a lot of experience working with unions and collective bargaining agreements, and so we would be able to conduct very quickly the complex valuation issues, the analysis that need to be done to see whether we need to rework those. So those are some of the key issues I think we can focus on, and just some initial thoughts on how we can help you guys really come up with some good creative solutions. Danielle also is going to talk about a couple bankruptcy alternatives that may be helpful, and then we'll open it up for questions.
I think that the time allotted has been taken up, so we will hand it over to the company for any questions that they may have.
You should ask about alternatives to bankruptcy.
I'll think about that.
Otherwise Danielle doesn't get to speak.
Well, I'll touch on it.
All right.
We've already done a good job, I think, internally of identifying our 10% lowest performing stores. We've already looked at the inventory that has moved, which isn't moving. We've looked at some new things. And I understand that you can help us a lot with the negotiations while we're in bankruptcy, because that gives us a lot of leverage over the landlords and getting rid of those leases. Really, one of my bigger concerns is about just the pure operations while we're operating under a Chapter 11. Clearly, my understanding is that once we file, we're not allowed to pay for outstanding trade debt, but I've got some critical vendors who may threaten to not ship me COD, cash in advance, on any way unless we take care of some of the old outstanding. Am I going to be able to get LCs? Am I going to be able to work deals with them under the bankruptcy code that's going to allow me to pay them and continue to get inventory?
Certainly. I mean, there are mechanisms under the bankruptcy system to help deal with critical vendors. And so what we would do is we would work with you to identify who those critical vendors are, and we would keep an open dialogue with them, about the process the company is undertaking. And then we can work with counsel to file a critical vendors motion to seek authority from the court to pay those vendors so that we can continue to do business with them.
Okay. And if we choose not to go down the bankruptcy route, what might be some of our other alternatives in dealing with liquidity crisis?
Yeah. Well, as it relates to your collective bargaining agreements, there are quite a few out-of-court alternatives that you could employ. The first one would be that, as it relates to your defined benefit plan, the first one would be to close the plan to new entrants, which would be known as a soft freeze. And you would still allow existing participants to accrue benefits, which would have the smallest impact. The second option would be to close and freeze the plan as a hard freeze. And this would be no new entrants, no one accruing any additional benefits. Third, you could seek minimum contribution funding waivers from the IRS. This can be helpful if your plan is supported and you guys are just experiencing short-term issues. And lastly, you could pursue a distress termination of the plan, which can be done in or out of court.
Well, those are interesting alternatives, but I think they only deal with a small portion of our problem.
Right.
So would it be fair to say there may not be other options that'll deal with our liquidity crisis or deal with the 200-plus pending lawsuits? So that's a real concern. But you had both spoken about the fact that, obviously, and we recognize that we need more money. And it's great to go to Yoga Bank, but what happens if they have no interest in dealing with us? Do you have relationships based upon your prior cases or resources that you might be able to tap into? Because we have a real concern that we may engage upon this endeavor and find out that our bank doesn't want to talk to us at all or give us additional funding, and then we might really be stuck.
Absolutely. Yeah, there are a number of instances where we have worked to, find industry appropriate and, loan size appropriate lenders. So yes, if Yoga Bank doesn't want to play ball and if the unsecured bondholders aren't willing to extend credit, then we do have relationships, and particularly with respect to retail, and that's something that we do every day is, call people up and say, hey, here's something that you may be interested. We think that this is a viable company, but they need some bridge financing, and we're that y'all are the right source of the lending for, for these business reasons. So we can certainly help with that.
And to the extent that you have some additional experience, I suspect that we might need projections or things like that. I'm assuming that's something that you could work with. I mean, Patty's fantastic, and we have a great team here, but they're really stretched to the limit. And we're a little concerned that we're going to run out of woman power to handle this.
Absolutely. I mean, one of the first things that our team would do is to sit down with you guys and really assess the financial health of the company. And when we're looking at potential financing options, we would build a dip sizing budget, and we'd look at what we think we're going to need to accomplish our goals.
Yeah. Do you have a sense of what that exercise would cost and how long you think we would be involved in this process? It seems like we're going to be borrowing money to pay a bunch of people to do a bunch of things, and we want to make sure we're coming out of this better off than we started, obviously. So I just want to get a sense of how you would keep control of that side of things.
Absolutely. I think what we would do is meet with you guys and gather additional information. I think we need to learn a lot more about the specifics of the challenges that you guys are facing, and talk to you about what your goals are. Because the path that we choose, or the paths that we choose to seek, are really going to drive part of that process. And so what we often do, because it's hard to kind of play choose your own adventure and know what's going to happen at each stage, we usually put together budgets at different stages of the case. And so I would probably break down a budget for you guys in 3 stages and say, here's the bankruptcy planning, here's what it's going to take to do your schedules and your SOFA and the filing and handle the financing, and that would be stage 1. And if we need to go through and say look at the collective bargaining agreements, that's going to require some complex valuation analysis, and that may be stage 2. So we would break it down in steps like that, so that we could understand and give you guys choices on the type of work we're doing. We're also fairly agile. We're kind of a mid-sized company, and so we're able to bring in as few or as many people as we need at different stages of the case. And we have a number of offices, so we always try and staff appropriately. If you hire us, you get us. We're not going to bait and switch. But to the extent that we can staff with people at rates that are appropriate for certain tasks, we will always be cost conscious.
You mentioned budgeting, and DIP will obviously have to, sounds like, raise new money. How much of a role is that lender going to play in that budgeting, and how much control are we going to have over how the money gets spent and how much is going to be driven by the lender and the process?
Well, initially, we would work with the lender or the potential lenders to achieve the most favorable financing terms that we can for you guys. And we will work directly with your management team to craft a budget. And then that budget, as approved by the court, after the various parties have an opportunity to weigh in, as well as the judge and the United States trustee, whatever the budget is as approved by the court, we will then live by. There may be some variance, flexibility under that budget, but that will be our framework to work within.
Do we have any other questions, Judge? Company? No, we're good? Okay, thank you both very much for joining us today. So, OO Orange has heard that if they decide to pursue a bankruptcy proceeding, they will require the assistance of a claims agent to help them manage the administration of the estate and to help with the management of documents. So they've reached out to BMC Group to come and meet with them to see how they can help. So with me today from BMC Group is Tina Marie File, who is the co-founder and president of BMC Group, a global information management firm and professional services firm with offices in North America, Asia, and Europe. Tina Marie brings 3 decades of experience directing various aspects of corporate compliance, communications, insolvency case administration, as well as the due diligence process in major merger and acquisition transactions. Tina Marie played a key role in the development of BMC's state-of-the-art virtual data room technology that is presently used in the US, Canada, Asia, and the European Union. Tina Marie is a member of the New York network and is a director at large of the IWIRC International Board. Also with Tina today from BMC Group is Oliver Zerbel, who is the Director of Business Development with BMC Group, and Oliver's networks with professionals in M&A, restructuring, and private equity, focusing on clients in telecommunications, natural resources, financial institutions, technology, and real estate. Welcome to you both.
Thank you.
Thank you.
Morning.
Good morning.
So, good morning. Ladies of Orange, let me introduce myself and BMC Group. Thanks for having us visit with you and present ourselves to you. Coincidentally, our corporate logo and pixel strip, as you'll see on the materials and on my business card, is orange as well. It's one of my favorite colors.
We appreciate you changing that for
We
us.
brought a couple of orange wristbands the kids might like.
Thank you.
I'm Oliver Zerbel, Director of Business Development, and with me is Tina Marie File, co-founder and president of Client Services and the head of our restructuring division. I've been with the company for 6 years and have assisted in the origination of a number of engagements for BMC Group, including several mega case filings, one including some $8 billion or more in debt, which is still ongoing. Why are we here before you today? I'm going to turn this conversation over to Tina Marie, unless anyone has a question at this point, to jump into the context and the nature of our work.
Great, thank you, Oliver. Thank you for taking time to see us this morning. As Oliver mentioned, I'm the president and a co-founder of BMC Group. We understand you're considering filing a Chapter 11 proceeding, and that's why we're here. Having started my career in the U.S. Bankruptcy Court as a deputy clerk, I saw a need for more efficient information management in the context of reporting requirements when involved in a Chapter 11. And as I hope you were told, in some districts, a third party is required, and they're often referred to as a claims and noticing agent. They are tasked with receipt and recordation of claims and the handling of legal notice to parties affected by the actions you take in court. We're a firm that handles those kind of tasks, and I brought some materials that I'll leave behind for you today. And I also have up on the screen some graphics that we'll focus on. I invite you to ask questions as I present to you. And as well, you can call Oliver or me day or night if you have questions or thoughts you'd like to discuss. I know we have limited time, so I'll focus on the graphics included in the materials that I'll leave behind, but do feel free to interrupt at any time. So this graphic depicts the many inputs and outputs typical in the Chapter 11 process. You're going to be asked to gather information such as vendors, suppliers, creditors, parties to legal actions. I know you're involved in a number of legal actions right now, contracts. And so the aggregation of all this information becomes quite a formidable task. And having a company such as mine really proves to be valuable. We collect, manage, and deliver that information in a way that is relevant to the process, and it allows you as decision makers to make informed decisions. Having seen, because we're an information management company, we created a secure web-based platform to collect, manage, and deliver the information relevant to notice parties and claimants in a Chapter 11 proceeding. This secure platform would be shared by you, your legal, and your financial advisors, and it also contains public pages that can be shared with your employees, creditors, vendors, and suppliers. We're an experienced team. As you may know, that I've been in the industry for about 30 years, and we have a dedicated group of team members, most of who have been with us for at least 10 years. Our dedicated group of team members allows us to be scalable, and that is to ramp up or down as necessary and to push work downward to the most cost-efficient billing level. For ease of your viewing reference, I'm going to give you a printout of this flow chart. This flow chart illustrates the phases of the Chapter 11 process and the role we would play in helping you navigate the process. You're required, as you prepare to file a Chapter 11, a lot of information must be gathered. The time before you file the Chapter 11 is called pre-petition. Pre-petition, you may be involved in bondholder identification, some kind of investor communications, different things such as exchange offers or contracts review. We have to set up an accounts payable protocol with you because once you file, you're not allowed to pay any of the debts that were in place before you filed, absent authorization of the court. Once you do file the petition, or the petition actually includes things such as corporate resolutions, petitions, list of creditors, 20 largest unsecured creditors with contact information is needed because those 20 largest unsecured creditors are solicited to be participant on what's called a creditors committee. Then you've got to have a master mailing list, and perhaps you might need some legal advertising to announce to the world your filing. These bits of information are all collected by us. We facilitate that collection for you and with you. And again, our platform, which is a centralized data repository, is used by your entire advisory team. Once the petition is filed, you can see the third part of the flow chart is schedules of assets and liabilities and statement of financial affairs. Now, obviously, your lawyers and your financial advisors and us really do have to work as a team, but we provide you with an overview of schedules, the information requirements, and the uses. We assist you in identifying the information and in the data gathering, and then we output that information on the schedule format. Once schedules are filed, that's the basis of liabilities that you believe are owed at the time of your filing. And then there is a claims process, and claims are filed, typically received by a firm like ours, BMC Group, and there's many ways to receive and record claims. First of all, now in the information technology age, there's the ability to accept claims electronically, or perhaps paper claims. Whatever the case may be, we are well qualified to handle that and actually can contribute recommendations to you based on whatever the situation may be. So we receive and record the claims, and those claims are resident in the centralized data platform. There is a value-added process that's included in our claims recordation, and that is to type the claims as they come in so that while you get a timely picture of what's coming in, there are these value-added tags such as, was it a litigation claim? Is it an employee claim? Is it a shareholder claim or a contract claim? These types of things, again, when timely provided to you, offer you a timely and accurate information to make informed decisions. There is a claims reconciliation process, and we train you or your team, your internal team, to be able to review the claims. Like, for example, you may want to add somebody from your HR team to look at employee claims. You may want to add somebody from the GC's office to look at all the legal claims. And the platform has that interaction and can even be qualified so that only certain people access the HR claims, or different types of access can be given, user authorizations. These claims, actually, I know we probably anticipate a large volume of claims in this case due to all your leases, your collective bargaining agreements, and your lawsuits. So I think it's going to be very important that there be a centralized platform such as ours to really manage that information. You're going to be preparing a plan of reorganization, most likely. And once you do that, it includes how will you pay back those claims? How will you treat them under your plan? So the next phase that we get involved in is solicitation of your plan. We solicit ballots to the claimants and encourage them to vote in favor of your plan. So there again, the technology and the information in our platform is leveraged to your benefit and for the ease of communication amongst your advisors. Ultimately, once your plan is confirmed, you're going to have to distribute upon the allowed claims. And therefore, we are involved in the distribution process. One of the things that we have found is that the claims that come in are not consistent with the claims in your accounts payable system. And therefore, for you to turn around and write checks isn't going to be an easy task, because you would actually literally have to input all that information into your system. So we leverage that information to execute issuance of stock, warrants, or cash, or whatever may be part of what was anticipated or contemplated in your plan. And thereafter, there is even a process that may last after your confirmation, and that includes objecting to claims, because by the time your plan is confirmed, all the claims may not have been reviewed. All the claims still need to be objected to. There may be claims that need to be objected to. So that process is ongoing. The value of a centralized data repository and a team that is experienced and understands what you're going through is going to be pretty valuable. So I hope that you'll select us to support you. And I think perhaps, Oliver, do you have anything to add?
Yeah, thanks, Tina Marie. Well, just in wrapping up here, while we've been called in today to pitch the claims agent role, we hope we've left the impression that as a broader information management service provider, BMC Group has the ability to truly take a 30,000-foot view related to the restructuring process. And should you have any offline questions,
Or even questions now?
Catherine, why don't you start?
Sure, put the Canadian on the spot. So on that note, I just want to understand your role and what the parameters are. Do you actually speak to our creditors and negotiate with them, or
Well, it depends. Yes, we are an information agent, so among other things, we would have a call center, a website that allows your creditors to have access to whatever is posted there, typically a mirror of the court docket, some information about upcoming hearings, deadlines, who the contacts are, for example, who is your counsel, who are the creditors committee and their counsel, who's the U.S. trustee, what's the judge's address and phone number, things of that nature. That would be on the public website. And again, we would support with a call center where there are business rules, and we would be able to escalate calls to counsel as necessary. But the beauty there is that you, your employees, and your counsel don't need to be bothered by literally thousands of calls that may be coming in. We offer that at a much lower rate and efficiency, and of course, then can escalate as necessary.
So given that, how do obviously, one of our concerns, as you may have seen from the material, is that our public reputation, our communication with our stockholders, and making sure that we do as best we can to maintain or rehabilitate our image. And so how is that message managed in a call center? Like, how do we make sure that the message that we want out there is
Sure.
followed?
It is typical when there's a situation such as yours that you bring in communications experts, basically a PR firm, and we would work hand in hand with them to ensure that the messaging is correct. And it involves a number of different things, but it's basically coordination and communication.
Is this fact-based information versus legal information? I'm assuming creditors, if they're calling a call center, are going to have a host of questions. You're not providing legal advice to them, are you?
No, certainly not. Thank you for asking that. We don't give legal advice or financial advice. Obviously, you're going to have professionals that are engaged to support you, legal and financial professionals. So again, there's going to be something like a frequently asked questions. There'll be a script that we develop together with you and the advisors and potentially the communications firm. And that way, we're very limited in terms of what we can do, but we are usually able to get people the information that they need.
And you mentioned something about an escalation process. I assume that the people that are working at the call center, even though they may be lower down the fee structure, are trained to sort of identify issues that really maybe need to move to somebody else's attention versus giving them something from the script.
Absolutely, and our call center personnel are also trained on our information platform, which allows them to have access to things that it's actually categorized so that you can indicate, they can know whether it's public information or whether it's private information. And in fact, based on user authorizations, if it's private, among the advisors and the company, they don't even have access to it.
I just have one more question. That is one concern, is if it's all on one platform, are you comfortable with the integrity of that system so that what's private does not become public? Have you had issues like that in the past? Obviously, from a privilege issue or business confidential records issue, we have some concern. The more information we have out there, even amongst the group, the more likely we're at risk.
Sure. I think Oliver may want to comment on this as well, but we are a technology company, and we have conducted multi-billion-dollar deals on our platform. We're very secure we're very confident in our security. In fact, we've passed batteries by some of the largest institutional banks because they're very concerned with privacy as well. So we're pretty confident there.
Thank you, that's comforting.
One of my greatest concerns as we've been talking to all the potential advisors is fees. And one of the things I noticed here on your proposal or layout is I see some things that perhaps are duplicative with what the financial advisors suggested they would provide. So I want to be sensitive to the fact that I'm not paying 3 groups of professionals to do the same thing over and over again.
Understood and agreed. In fact, that's why having a firm such as mine with a centralized platform is pretty valuable. Obviously, your team, whoever you engage, they're going to have to work together as a team and agree to avoid duplication of effort. And of course, I don't know if you know this, but the court requires fee applications, and there's U.S. Trustee and Creditors Committee. These people are also interested to ensure that duplication of effort does not occur.
Okay, great. And then, one of the other questions I had is, in this call center, so creditors are calling you, they're calling us, they're calling you, they're calling, our financial advisors and our attorneys and everybody because, maybe they're putting in a claim, and do they get to see what the company says our liability is to them? So maybe we're suggesting we owe them, $100,000, and they're saying, oh, no, you owe us $200,000. Who gets involved in reconciling that?
Okay, so yes, there's that claims process. So you file your schedule of liabilities. We assist you in collecting that information and presenting it in the form that's required by the court. So that's a schedule of liabilities, which is the basis. And then claims are filed. We receive and record those claims for you. And as I mentioned, we might claim type them so it's easier to get to them. But at any rate, you can look up on the system the claims, and you'll have a reconciliation and claims objection process. Now, different people can be involved in that, and again, that's just a matter of agreeing on whose responsibility is what, but financial advisors absolutely play a part in understanding what that is so that they can facilitate a reorganization plan for you. And then, of course, your legal counsel will play a part too. So we all play a part, and the key will just, again, be not to duplicate efforts.
Okay, thank you.
Did you have any more questions for BMC Group?
Do you need us to ask more questions?
No?
Is this time to fill? No.
You timed it very well. Thank you very much, Tina and Oliver, for your pitch today.
Thank you.
Appreciate it.
Thank you. Thank you for your time.
So while the OO Orange case is very interesting and the issues are challenging for all, the title of this morning's presentation is Pitch Perfect. So the goal of the session was to look at various types of pitches and looking at different styles of pitches, what resonates with you, what did you learn today, what would you do differently, what has worked for you, what's been successful in the past. I'm also interested in getting people's views on the personal touch, which was used in at least one of the pitches this morning, and how successful has that been for you, or does it sometimes backfire? So I'm going to open the floor for questions, comments, either to the panelists or just to the group in general, so that we could share our experiences on pitches, and very interested in what things resonated with you this morning.
Nothing.
Bernadette?
I have two comments, and unfortunately, I have the same problem, so I noticed it. There were a lot of people that said, "you guys," and this is, you gotta know your audience, and to say to 3 women, "you guys," 12 times during your presentation, I think hurts you. And ironically, all you have to do is say "you," just drop off the word "guys." And someday I'll learn that lesson myself.
Unless you're from the South where you say y'all.
Well, you all.
Yes. There's a lot of y'alls going on.
And I accepted that. Okay, the other thing was, and Danielle did it a little bit more than some of the others, but I think Tina Marie did it as well. You were turning toward the customer, but yet you continue to refer to your documents on the table. And especially Danielle, I would have picked up the paper so that she didn't have to continually turn to the table to see her notes. Just changed her presentation given the circumstances of where she ended up sitting.
I think that was a challenge today. What we had hoped to do was to have each of the teams facing the company, which is much more realistic in what you'd have happen. Just with logistics today, plus the taping, that was a bit of a challenge, and so we had to make do with what we had. So appreciate that. Tina.
Bernadette is right. You're going to always have to adjust yourself. You don't know what your situation would be, so I think the point is well taken. You're going to have to figure out how to properly present depending on whatever you're faced with.
Sherry?
I'm Sherry Dahl, for those of you who don't know me. I'm going to give a real gender-biased comment. Mr. Lee, you're in a tough room with a tough crowd and a tough audience. But I got to tell you, I was listening to you for a short while, and then I got very distracted by the fact that you're a man talking to 3 women, and you have a young woman with you, and she didn't say very much. And so I found myself being so distracted, thinking for a very long time, why isn't she talking? Why isn't she talking? Why is he talking so much? And really, I didn't catch a lot of what you said because I was so distracted with this discussion in my own head. So that's it. That's my 2 cents.
If I can piggyback on what Sherry said, actually sitting up here, and I did listen, and I think it was a great presentation, and I'm happy to comment on that. But for the longest time, I'm going, is Becca going to speak? And it's worse here because you had a male and female, but having been in pitch rooms, let's take gender out of it for 2 seconds, having sat there, and sometimes people come with 2 or 3 people, and 1 or 2 say absolutely nothing. I always sit there and wonder, are they overstaffing this? Are they going to overstaff my file or my case? Because where's the value add for having these people? Now, at some point, she did get to speak and was very pointed and all of that, but I think across the board, anytime you have multiple people, they have to be more than just the person that's handing out the handouts. But Sherry's point's even better taken. When you have women, let her speak more. Absolutely, but I want to say something very positive, because one of the things that I really liked about your presentation collectively is that clearly you really had thought about what we might ask, and given that you had the US-Canadian, you were very upfront about, no, we don't have an office in Canada, but we do this, and it really doesn't matter. We've done all of these kinds of issues before. We're aware of the fact, but it's sort of like dealing with the elephant in the room, because that could have been a real downside, and instead you took it and spun it positive before anybody had the chance to say, yeah, but you don't have anything there. How are you ever going to deal with this? So, and there were a couple of other things that you did similar points with during the presentation, and I think that's a great way to take charge of it. You can't hide an issue. You just got to be upfront and address it, and then I think it becomes a non-issue a lot of times. So I think that was a great positive.
Great. Is someone in the back?
Yeah, hi, I'm Katie Stadler from Godfrey & Kahn in Madison, Wisconsin. This was a great presentation, really interesting to sit in this perspective and watch and critique. I love the comment, and I understand you're wanting to take gender out of it for a second, but I want to put gender back into it for a second with this question. I don't know how many of you have read this month's Atlantic article about confidence and women lacking confidence in contexts just like this. And the importance of confidence in presentation, but also the importance of confidence being genuine and not being perceived as bluster or chest pounding. And I wondered if any of the panelists or the participants, the pitch participants, could comment a little bit about that fine line that we walk between, tooting your own horn and bragging or boasting about your capabilities. And do you think that we as women face a little bit more of a challenge in a context like this, especially if you're not pitching all to women?
Well, I think women do constantly, we don't act like men do when they walk into a room. I think that we do tend to downplay a little bit. We might defer more than we should. I was actually mentioning this to someone last night, that my male colleague, he's got a phrase, he fakes it till he makes it. Like you have to present, you have to project, you have to, and half of us in the room are litigators. You got to go in there and believe in your case, whether it's a winner or not. So I think that we have to work maybe a little bit harder sometimes to put ourselves out there, but
And I think there is, and it's a hard line that you raise between being a show-off or, you know, being confident. And sometimes, I think we'd all agree, sometimes men seem to get away with it a little bit differently, but it may be your audience. You know, if you've gone into a room of all men, maybe your approach needs to be different, not downplayed too much, but different than if you have a mix in the room. Same if you have lay people or professionals in the room. During the course of your presentation, Becca had an opportunity, and I think you handled it well, where you talked about, and I don't remember the exact specifics, but you identified a case that you had done in under a year, you'd done it in 7 months, and it didn't come off as too much, you know, pomp and circumstance. It wasn't offensive. I think it was appropriately responsive to our questions, so it had a good place, and it wasn't like you just got it stuck into the presentation regardless. And because it was responsive, it was better received than if you had just sort of dropped it in the middle of something and said, you know, we're great, we've handled one of the biggest cases going, and woohoo, we did it in 7 months. So it's also how you place the comment, I think, that matters, and that was well done.
I have to agree completely with Leslie's comment that it's your audience, right? I'm sure many of us have walked into situations where you've been in a boardroom and 19 of the 20 people in there are men. Mm-hmm. And you got to play to that. You know, you can't be frilly, girly, talking about things, women's issues in that room necessarily when they are there to talk about baseball and football or golf or whatever it is that they want to talk about. You need to be able to talk on their level or topic, or at least show some interest, some basic level of knowledge, or they're going to tune you out. I don't care how smart you are, I don't care how much experience you've got, I don't care if you're the most senior person in that room with 19 male counterparts, you're going to need to be able to talk their language. Just like I'm sure you coming here into a group of women, you know, it's not the easiest thing in the world, right? You need to be able to show some interest in what we care about.
Well, I don't know what the microphone is, and I probably don't need one, to be honest. But just to respond to the comment was made, and it's very interesting to hear all of your comments. Based on my almost 40 years of experience, when you're in a bet the company situation and you walk in, and I don't care what your audience, whether it's male, female, whatever's going on, those people care about saving their company. That's first and foremost.
Amen.
And over my years of experience, it's not a male-female deal. We made a conscious decision based on the fact that they want to hear from the top guy, the more senior person, what are you going to do for me? And it's not a matter of did the lady get to speak as much as the man or anything of that nature. They want to know, okay, she can come in and say all the things she wants, but where's the buck stop? And so we made a conscious decision that I was going to do more of it. Not that we weren't aware of the audience, but taking that risk, because in reality, in those types of a situation, they want to hear from the senior lawyer. If it's a woman, if it's a man, whatever, they want to hear the person that's going to run the team. And they want to know that they have confidence and trust in them, because they realize that the underneath staff you may adjust and everything else. They want the person who's got to answer to them. And so that's why we did it. So, and I learned something from, it may be a distraction from someone from that perspective, but having been in a lot of these over the years, that's the takeaway I've always had. So that's why we did it.
And I think the other side of that.
Oh, no.
Well, you got to let Becca speak.
You're right, okay, I agree with you. Right now, they want to hear the best person, the top guy, whether it's a man or a woman. But as time progresses, and one of the reasons right now that's still the man most of the time is because we don't have enough women who have risen to the level of top guy that half the time it can be a woman. But what's going to happen, and hopefully it happens in my lifetime, which would be about 20, 30 years, if I eat better. But anyway, hopefully in the next generation, we're going to get to a point where there are 50% women at the top, and we have 50% women top guys. And if firms don't prepare now for that eventuality, then there is going to come a time when there are going to be enough women making the decision that they'll be distracted like I was, and there will be 50% of your competition putting a woman as the one who's speaking. And so you might lose work because where you're otherwise equal, if there's a man and a woman might pick a woman to get the job. You had a great opportunity here, and you do in the future after you leave here, to mentor the young woman and teach her and train her and tell her what she needs to say so that at least during 50% of your presentation, she could be faking it. You know what I'm saying? I mean, she could be giving the presentation. She doesn't have to actually have 20 years of experience to give the presentation. She can say, our firm has all this experience, and you could have given her 50% of the presentation today, but that would have required extra work on your part. So I'm just saying, we have the opportunity now, and
Share.
So in fairness to Jim, and I was actually just going to say this too at the end, is that so last night when we were preparing, we actually had this exact same conversation, and he was asking if I wanted to, take the lead and do this part, and I said no, because I did do the trial.
mistake.
Hey, at least they're having the conversation.
That's right.
Well, that's what I was going to say, is that we just successfully did a pitch a few months ago, and I feel very lucky because I'm one of the few associates, man or woman, at my firm that I'm frequently brought on pitches by the guys that I work with, and I do speak at them, but of course we always have, like in this particular pitch, it was more litigation oriented, so Jim spoke first, and then the guy who was the head of our section, because he had less experience in this instance. And then it kind of goes back to your question about trying to promote what you can do, and I would have bring in specific experiences that I've had, because in my own experience, when I'm talking to two people and I'm asking a question and the junior person keeps on piping up, and I'm like trying to find out, like I want the real experienced answer, we wanted it to be realistic in that regard. And so, everyone that I go on, I speak more at, but that's why we did make a conscious decision that now we can all penalize.
Point well made and well taken, and so, I mean, this has been learning to me as well, so it's accepted in that light.
I think the point is inclusion, right? It really is. And so Maggie did this well when she commented specifically, this is the team that you're going to get.
Right.
Like, we're not doing a bait and switch. And so this is a team, and one of my partners had a situation recently, and it was a very expensive job that they went in and pitched. And the client said, I want the pitch to be from the people doing the work.
Yes.
Yep.
They didn't, when they went there, they didn't want to hear from the partners. They wanted to hear from the team doing the work. And we lost the job because we weren't prepared for it. But we got a chance to pitch on it again and brought the team back and won it the second time. But we lost it the first time because nobody was prepared for that, for those people to be there. And that's the people that they want in the room. So if Becky's going to be doing the project and is going to be working on it, I think you can manage that process, to Sherry's point, to have it more inclusive. Lots of comments. I think Jen was first, then I'm going to go to Karen and...
About know your audience, and one of the things that I noticed Oliver is doing is using a lot of acronyms that we use in bankruptcy all the time: cash collateral, DIP, SOFA schedules, things like that. And I just, I bring that up because a lot of times you go to companies, they've never dealt with bankruptcy before in their life. They don't know what the automatic stay is. And so I just point that out because you have to remember to know your audience and make sure you really get to the basics sometimes of what those terms are.
Yeah, that if we'd had a longer process, I mean, I would have been sitting here going, what's a dip?
I mean, sofa.
But because we're only asking one or two questions, I mean, but, yeah.
True.
Yeah, that's
No,
true.
it is a good point. And we tried to sit here, as obviously you could see, and we met and said,
Yeah.
we have to pretend we've really never heard of this before, as opposed to trying to listening to it with the ear that we normally bring to it. So some of the questions were like, what have I've heard about these committee concepts, but I don't know about them per se.
What do I do with vendors?
Right, which quite frankly, we all know what to do with.
Yeah.
Great, so Beth and Karen?
Yeah, I just wanted to say really quickly, as having sat through many of these types of presentations, that
to echo the other comments, that audience is really all about it, absolutely. Know your audience, make sure that when you're making comments about the company, that you know the company. I had recently spoken on a similar panel up with the Neon Network, and one of the things I can't stress enough is that if you go into a company and you don't know the name of the company or the history of the company, and I kid you not, it's happened. It's really problematic. I know you think that doesn't really happen, as I've shared this for people that know. The company that I used to work for used to sell tires about 30 years ago, and I still have people that pitch us work that say, well, in the tire industry, well, I'm glad you know about that, but I don't do anything in the tire industry, and I haven't for 30 years. Or they call the company the old company name. I mean, it's little silly things like that you have to be careful about. But the comment that we're talking about from the gender perspective of the you guys, that's something that you really do notice. And I was laughing about the y'all thing, because what I've really come to know, having moved from the north to the south, is that I use y'all all the time when I'm in the south. But if you're not in the gender neutral, but you don't use that anywhere but in the south. Because if you go up to the north, people, rightly or wrongly, tend to look down on that for some strange reason. It's a colloquialism that people are like, especially when you're up in New York, no offense.
Especially if you're from Canada. And when you add all in front of it, it makes no sense.
All y'all.
All y'all.
Yeah. All y'all.
So we are out of time, and we're into your break, which I'm sure people are anxious to get to. But I'm glad that it went over, because it meant that there was a lot of interest, and it's a great topic and is of interest to everybody. So I'd like to thank our teams today. I think they did a fantastic job. And our representatives from the company. So thank you.